Constitutional Rights Handbook, published by the Secretary of Department Affairs, Florida, United States of America. Revision 13595609448. Table of Contents. See the website fireacop.com. For further information referred to in this document, complaint forms, and online complaint filing system. 1. Constitutional Law, page 3. 2. Police Misconduct, page 3. 3. Suing police officers, judges, court clerks, and other government employees and contractors, page 6. 4. Taking the law to court, page 8. 5. Fundamental rights, page 11. 6. Police authority, page 16. 7. What kind of assistance is available, page 17. 8. How can you participate, page 17. 9. Reasons to file a complaint, page 18. 10. Case law, page 19. 11. Doing legal research, page 20. 12. Internet legal resources, page 20. 18. U.S.C. Statute 241, Conspiracy Against Rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district, and the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highways or on the premises of another, with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. 18. U.S.C. Statute 242, Deprivation of Rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, than are prescribed for the punishments of citizens, shall be fined under this title or imprisoned not more than 1 year, or both. And if bodily injury results from the acts committed in violation of this section, or if such acts include the use, attempted use, or threatened use of a dangerous weapon, explosives, or fire, shall be fined under this title or imprisoned not more than 10 years, or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping, or an attempt to kidnap, aggravated sexual abuse, or an attempt to commit aggravated sexual abuse, or an attempt to kill, shall be fined under this title or imprisoned for any term of years or for life, or both, or may be sentenced to death. You don't have to put up with this bullshit at all, and perhaps the sickest thing about it is that you never did have to. 1. Constitutional law. As you sit in the lobby of your local municipal or petty court, if you are offended by the fact that you are there to subsidize the existence of a class or otherwise unemployable, horrific people with no concern for your existence, basically lazy, worthless thieves, the various operators, the clerks behind the bulletproof glass, in parentheses, why bulletproof glass anyways? Should a legitimately acting government officer need to protect themselves against attack by the public for carrying out their official duties? The police, judges, and various operators at the periphery try to gain some insight into their personalities. What kind of people would carry out and engage in such conduct toward their fellow citizen? Would you? If the answer is no, then the law is on your side. More important, it is the supreme law of this land, the constitutional law. Constitutional law means 1. The Constitution of the United States of America. 2. The Constitution of each of the several states, in parentheses, each U.S. state has its own constitution, being sovereign entities themselves, separate, and in addition to their inclusion in the federal union. 3. The interpretation of those constitutions are passed into law by legislative bodies like the U.S. Congress or state legislature. 4. The interpretation of the state and federal constitution as challenged or otherwise judged in court. 5. Constitutional principles as enforced by various agencies. 6. The law acceded to as custom by the people that have existed for more than 200 years in this country, and as under the crown back to and including the Magna Carta, in parentheses, almost 600 years. To simply say that the Constitution protects your liberty is not enough. The constitutional law of this nation protects your liberty. That's right, liberty. It's not just a good idea. It's the law. Your liberty is so strongly protected that federal law provides that those who deprive others of their constitutional rights may be put to death, incarcerated for life, or periods of up to 10 years for non-capital violations, or face civil penalties for non-criminal offenses. The specific laws that protect you this way are Title 18, Sections 241 through 245 of the United States Code, usually abbreviated as 18 U.S.C. Statute 241 through 245, and Title 42, Section 1983 of the U.S. Code, in parentheses, 42 U.S.C. Statute 1983. Massive amounts of civil rights law can be found on the internet simply by searching for these statutes. 2. Police misconduct. Police misconduct is any conduct that you consider mis. You dictate every aspect of their behavior to them. Period. In parentheses, see FRS 447.209. If you consider their conduct as mis, then it is misconduct. The Department of Justice has published a paper on police misconduct located here. http://www.justice.gov/crt/CRT/PUBS/POLMIS.txt. They encourage reproduction of that document. It is reproduced on fire. Cop.com. In addition, the website has pre-printed forms you can download, instructions on how to file various complaints, and we offer services to assist persons interested in filing administrative or judicial complaints against police officers or any officer for profit. All the further material necessary for a person to bring lawsuits and complaints against any state official is on the website. Please take advantage of pre-printed forms and our complaint database. Likewise, the statutes and constitutional law mentioned here will be published there so that you can read it directly. Jail inmate was, quote, citizen, within meaning of provision of this section, making it felony to conspire to interfere with citizen in free exercise or enjoyment of any constitutional or federal right despite fact that he was a convicted felon. U.S. v. King, C.A.5, in parentheses G.A. 1979.587 F.2D 209. An office is a public employment, and in the performance of its functions, the citizen selected to represent the sovereign is in the exercise of both a private right or privilege and public duty, and a conspiracy to hinder, oppress, and injure him, and the discharge of such functions cannot be regarded as directly solely against the official in his representative character, but must be considered as also against the citizen exercising or enjoying the right or privilege of accepting public employment and engaging in the administration of its functions. U.S. v. Patrick, C.C.M.D, Tennessee.1893, 54 F. 338. It is not necessary to find that the conspiracy charge was formed against a particular individual, but it is sufficient if it appears that he was included in a class actually conspired against. U.S. v. Butler, C.C.S.C, 1877, 25 F.CAS. 213. This section, prohibiting conspiracy to injure, oppress, threaten, or intimidate any citizen in free exercise or enjoyment of any right or privilege secured to him by Constitution or laws of the United States, extends to conspiracies with respect to rights and privileges protected by 14th Amendment, and extends to conspiracies otherwise in scope of this section participated in by officials alone or in collaboration with private persons. U.S. v. Price, U.S. MISS. 1966.86 S.CT 1152 383 U.S. 787 16 L.ED.2D 267. The mere acquiescence or silence or failure of an officer to perform a duty does not make him a participant in a conspiracy, unless he acts or fails to act with knowledge of purpose of conspiracy and with view of protecting and aiding it. Lutheran v. U.S. C.C.A.8, in parentheses M.O. 1937.93 F.2D 395. The fact that members of a conspiracy to offer violence to prisoners under arrest are in charge of them as deputy marshals or guard does not lessen their guilt. U.S. v. Logan, C.C.N.D, Tex. 1891, 45 F. 872. Statute prohibiting conspiracy to interfere with rights secured by Constitution or laws of the United States creates no substantive rights, but prohibits interference with rights established by Constitution or laws and by decisions interpreting them. U.S. v. Kosminski, U.S. MICH. 1988.108 S.CT. 2751.487 U.S. 931.101 L.ED.2D 788. This section prohibiting conspiracy to injure, oppress, threaten, or intimidate any person in free exercise or enjoyment of any right or privilege secured to him by Constitution or laws of the United States, embraces all of rights and privileges secured to citizens by all of Constitution and all of laws of the United States, and was not intended to be confined to rights that are conferred by or flow from federal government as distinguished from those secured or confirmed or guaranteed by Constitution. U.S. vs. Price. U.S. MISS.1966.86S.CT.1152, 383, U.S. 787, 16 L.ED.2D.267. Arrestees or detainees enjoying constitutional right to be protected against assaults perpetrated by arresting or detaining officers that was sufficiently definite under decisions or other rules of law to support civil rights, prosecution of housing authority officers, U.S. vs. Reese, C.A.9 in parentheses CAL. 1993, 2F.3D87. Statute prohibiting conspiracy to injure, oppress, threaten, or intimidate any inhabitant of a state in free exercise or enjoyment of right or privilege secured under Constitution or laws of the United States applied to alleged 14th Amendment violations by city transit police officers. U.S. vs. McDermott, 2.A.2 in parentheses N.Y. 1990, 918. F.2D 319. In order for a person to be guilty of crime, of willful deprivation of constitutional rights while acting under color of law, defendant's action must be done under color of law and, where use of force is involved, force used must be unreasonable and unnecessary. U.S. vs. Stokes, C.A.5 in parentheses GA.1975. Prosecution for deprivation of civil rights does not depend upon death or serious physical injury to victim. Penalty is subject to enhancement if death results, but that does not concern guilt or innocence of the crime. U.S. vs. Calhoun, C.A.4 in parentheses W.VA.1984. Mistake of law will not generally excuse commission of offense. Thus, defendant's error as to his authority to engage in particular activity, if based upon mistaken view of legal requirements or ignorance thereof, is mistake of law, and fact that he relied upon erroneous advice of another is not. Typically an exculpatory circumstance, he will still be deemed to have acted with culpable state of mind. U.S. vs. Barker, C.A.D.C. 1976, 546, F.2D. 940. Prosecution for conspiracy against citizens' rights in violation of election laws was not subject to dismissal under doctrine of de minimis. Fields vs. U.S. C.A. 4 in parentheses V.A. 1955, 228, F.2D. 544. This section, prohibiting conspiracy against rights of citizens, does not require that any overt act at all be shown. U.S. vs. Murado, C.A. 5 in parentheses T.E.X. 1972, 454, F.2D. 167. 3. Suing police officers, judges, court clerks, and other government employees and contractors. The goal of this document is to assist citizens in putting a stop to unconstitutional practices by the state through its various individual operators. State officers violate citizens' constitutional rights every day. Every citizen who has had government action taken against them has had their constitutional rights violated. There is not a single police officer who does not violate citizens' constitutional rights every day, and who does not do so in almost all their conduct. Note: when taking legal action against the state for its actions, the law of individual responsibilities applies. To sue the state as a party in court means literally to sue yourself as much as anybody else. And so, it may not make much sense to do so in redressing constitutional grievances. In fact, the 11th Amendment of the U.S. Constitution has been very repeatedly upheld to act as a bar to naming the state as a party in federal court. As a legal question, however, one has to ask, how does the state's appearance in federal district court as a party plaintiff act as a waiver of its 11th Amendment immunity, or otherwise, as consent to appear as a party defendant? So as a practical matter, the procedure is to sue the individual police officer, judge, court clerk, psychologist, social worker, DHSMV worker, elected official, or whoever the individual is that did the act, as opposed to the state as a governmental or political body. In that suit, one can seek criminal charges, monetary relief, or other relief. If you are after money, be prepared for a long haul and a lot of work, not to mention needing a legitimate claim for damages. Money is generally paid where real property or physical damage is suffered. In parentheses, there is, of course, no excuse for any harm caused to an individual by actions of a state official, but those involved are typically deliberately indifferent because, if nothing else, the state has an insurance policy to cover them. As for being able to claim damages on basis of emotional harm or emotional distress, one may be able to complain on these grounds. Male equivalents to these may include provocation, insult, snub, harassment, punking you off, mocking, or dissing you. In other words, if causing someone emotional harm, in parentheses, whatever that is, or however that is done, is considered a good enough reason to sue someone, in parentheses, it is, then for some police or other state officer acting in such a manner as would provoke any reasonable man to a justified act of violence against them, but that when done during their official employ would cause you felony charges exclusively due to that employ for correctively disciplining the conduct of an errant public servant, then you have grounds to sue. It's just that men are more likely to want to beat someone's ass as opposed to crapping their pants or whatever. So, the concept of emotional distress being applied to men makes not much sense. In legal terms, adequate provocation is the male equivalent. It should be noted that none of the sort of conduct mentioned above is part of official duties of any public servant, and so when they act like an ass to you, they are literally off the clock. The nickel and dime usurpations put down daily by these creeps is disgusting. And in the end, it's how such things get carried out. Unfortunately, a nickel here, 10 cents there, pretty soon you're talking about big money. However, you can get a refund. In order to do that, you do not have to sponsor a ballot initiative and collect thousands of signatures. In America, we have 3 branches of government. When people collect signatures for a ballot initiative, they are acting as the legislative branch to amend, pass, or repeal a law. In the judicial branch, court, the way that one petitions their government for a redress of grievances is to sue. It is important to make the distinction, as this point between lawsuits for money and lawsuits for other kind of relief. This document concerns the latter. The federal court rules, in parentheses, Federal Rules of Civil Procedure, provide that declaratory judgment actions may be moved up the calendar. FRCP Rule 57. This means that a suit brought for the sake of settling the question can be heard quickly. Likewise is true in the state courts. Again, the reason is that when suits are brought for money, a whole lot of litigation needs to be done to make sure everybody gets their filthy little piece. When a question is brought purely as a matter of law, making the case can be very straightforward. In other words, when seeking only non-monetary relief, you can get quick results. Non-monetary relief includes, but is not limited to: 1. Injunction relief and declaratory relief. A. Injunctions typically will compel a person under threat of criminal charges or contempt of court to do a particular act or likewise cease and desist some act. B. Declaratory relief can be thought of as the court declaring something, like for instance that a particular statute, policy, or custom is unconstitutional. Any person can challenge any state or federal law in federal court, pursuant to 42 U.S.C. Statute 1983. The cost for this starts off at just $350 in parentheses the current filing fee. When you file your complaint, the cover sheet that the clerk hands you to file with your complaint will have a check box indicating the type of complaint being filed. Check the box for cause of action, hashtag 950, constitutionality of state statutes. If you do not have any money, you can file your complaint for free, because this is America, and that's particularly how we roll. It is called filing a complaint in forma pauperis, Latin for broke. 2. Extraordinary writs, mandamus, prohibition, habeas corpus, certiorari. A writ may issue when there is no other plain, speedy, or adequate remedy available. It can be thought of as a type of emergency action as opposed to an ordinary one. A. Mandamus. M-A-N-D-A-M-U-S. A writ of mandate to compel a particular individual, board, or body to perform a particular act. B. Prohibition. A similar writ as mandamus to prevent a particular individual, board, or body from committing a particular act. C. Habeas corpus. Get out of jail free. So to speak, a habeas action can be used when a person is illegally held, but can also be used in other cases where a person's liberty is restricted, in parentheses, typically by a criminal charge or sentence. D. Certiorari. C-E-R-T-I-T-O-R-A-R-I. A writ that certifies a lower court's ruling. This is the type of case most often brought to the U.S. Supreme Court when a judgment or ruling is rendered in a lower court, in parentheses, like a criminal conviction, and a person appeals. The U.S. Supreme Court becomes the forum of last resort. To challenge a lower court's ruling, you ask the court to certify the lower court's ruling is correct, or otherwise explain why it is wrong. If the Supreme Court finds the lower court's ruling as being wrong, your challenge was successful. 3. Equitable relief. Getting even. Equitable relief is where you can get creative. For example, if a police officer takes your driver's license, getting a court order to make them stand in line at the DHSMV office to get a replacement instead of you would be an example of equitable relief. There's a form for that on the website. 4. Taking the law to court. 1. Filing the complaint. So, to challenge a law in court, one can file a complaint in federal court and ask the court to declare that a particular statute, policy, or custom is unconstitutional, and get an order from the court telling the other party to cut it out, or else. Likewise, state laws can be challenged in state court, thanks to, in parentheses, in fact, and very great thanks to, the Uniform Declaratory Judgments Act. In parentheses, in law, a uniform code is a body of law adopted across two or more states or legal entities. The Uniform Declaratory Judgments Act is adopted in every state and the U.S. This means that you can walk into the Palm Beach County Circuit Court, file a claim that says, Florida statute section number XXX.XXX is unconstitutional because lay out all the reasons it is, and depending on the type of claim presented, either you will have to prove your case or you simply challenge the state on the law in question. And then they would have to prove you wrong. And that, as they say, is where it gets interesting. Thanks again to the founders of this nation. You can file a fairly simple complaint in state or federal court and almost always be in the position of calling the state out and making them prove the necessity of the law. The key concept here is fundamental rights. In those cases where the burden is on you to prove unconstitutionality, the key concept is arbitrary and capricious. 2. Standards of review. The first instance mentioned above, where the state must prove the constitutionality of the law, is referred to as the strict scrutiny test. When fundamental rights are repugned, the state must show that both a compelling object must exist and that there is a lack of less restrictive alternative. In parentheses, both these elements must be true. The second case mentioned above, where the burden is upon you to prove the law wrong, is referred to as the rational basis test, the idea being that passing laws and such is part of what the state is there to do, and if fundamental rights are not repugned, when the plaintiff must show the equivalent of that law is worthless, does nothing, or worse. There is a third standard of review, middle review, where the court sees fit to apply whatever aspects of the other two need be, when the distinction is not clear. Disturbingly, engaging in commerce is not considered a fundamental right, and as such, laws affecting commerce are subject to the looser standard. However, claims brought in court challenging laws, conduct, policy, or customs that affect fundamental rights put you in the challenger's role and the state, in parentheses, or state official, and the defendant's role. When people talk about the American way, this is one of the things they are talking about. 3. Procedure. So, the procedure becomes one of 1. Filing a complaint in state or federal court. Demand a jury. 2. Serving copies of the complaint to the other party. 3. Wait for their response. Then, 4. Reply to that. After filing the original complaint, you can use motions to make requests of the court. Parentheses, you can move that the other party be subject to a mental exam, for instance, or that they have their property seized, or that they be prohibited from making any further contact with you or some other party, that they may be prohibited from entering a particular area, or that they be suspended or removed from duty, to list some examples. Use requests for production of evidence to obtain evidence, in parentheses, like public and private records. Motions to compel if they don't provide the evidence you requested, and depositions to interrogate the adverse parties. During the course of the case, you may or may not get any court dates, or even a trial. You may or may not get any or all of what you seek. You may win the case with a slam dunk. The judge knows you're right, the state knows they're corrupt, in parentheses, they knew it all along, kind of like children who stir up trouble just to get attention, and they need to get yelled at, so they just go away and suck their thumb for a while until they come up with some other shit they want to pull. In that case, at least, the order can come from the bench, and there is no need for a trial. If the matter does go to trial, it is important to demand a jury. Juries can be assembled in declaratory judgment actions, and it is a great way to get your community involved. A brief digression at this point for the haters. If you are a psychology, mentality, personality type, or a socialist, in parentheses, the two may be related, or even worse, you are a communist, or otherwise gain filthy lucre from contracts and associations with state organizations, you are probably against people challenging the state in court like this on some kind of personal or economic grounds. In parentheses, i.e., you make money off these state operations by impounding cars or providing social or services to the court and earn your living this way. For you, it is pointed out that there are plenty of shithole countries that do not allow citizens to challenge the state in court. You are free to go there. As for the particular objections that people clog the courts with these claims? Simply, we pay for this service. If need be, they can open more courts to hear civil rights claims against state officers. The state can divert funds from the taser budget, in parentheses, $1,000 apiece. Perhaps the worst snivellers are the psychology mentality types. It turns out that their shop manual lists suing people as a disorder, in parentheses, kind of like voting, right? Beware of these people. Okay, so how do you end tyranny in America? Fill out a form. But if you are going to take the time to do your paperwork, you might as well get something for it. Why not ask to get individual cops and individual servants fired? And while you're at it, also seeing to it that they refund all their earnings to the state, forfeit all pension and benefits, and be prohibited from any kind of future employment for association with the state, as in, their whole career was a waste of tax dollars. They owe it all back. Or otherwise you can seek the end to whatever hassle you are having to deal with today. Here are some other guidelines to apply when formulating a constitutional claim. 1. Are you pissed about something the state is doing? In order to prevail in a claim, one must have standing. The minimum requirement of standing is that one be an aggrieved party. 2. Can you identify the specific person or persons responsible? The law of individual responsibility applies. This brings to the forefront some legal history. This legal precept was perhaps most notably to date applied at Nuremberg in 1945 through 46 during the trial of NSDAP officials as war criminals. For that trial, our own Justice Robert H. Jackson from the U.S. Supreme Court appeared as prosecutor for the American sector and stated, regarding the law of individual responsibility, quote, "Of course, the idea that a state, any more than a corporation, commits crimes is a fiction. Crimes always are committed by only persons. While it is quite proper to employ the fiction of responsibility of a state or a corporation for the purpose of imposing a collective liability, it is quite intolerable to let such a legalism become the basis of impersonal immunity. The Charter recognizes that one who has committed criminal acts may not take refuge in superior orders, nor in the doctrine that his crimes were acts of states. For those convicted, the sentences handed down included life in prison or death by hanging, in parentheses, very unceremoniously in some nondescript building in bombed-out Berlin. 4 judges were impaneled, one of each the American, English, French, and Russian sectors. As in any multi-judge panel, like state or federal court supreme, when decisions are handed down, there will be a majority opinion, in parentheses, the effective decision or ruling, or each judge not in the majority may file a concurring opinion, in parentheses, they agree with the majority but wish to add distinction to it or clarify, etc., or a dissenting opinion, in parentheses, they do not agree with the majority and explain why. In the case of the trial at Nuremberg, all 3 Western allies were the majority opinion. The Russians preferred the dissenting opinion. Their dissent was that the sentences handed down were not punitive enough. 3. Can you identify the specific wrong that needs correcting? This is very, very important, and it takes some knowledge of constitutional law to put into legalese. However, the good news is that if you feel that you have been wronged by the state, you probably have been. That is the place to start. Identify all the aspects of the circumstances and how they are wrong. Focus very firmly on fundamental rights. 5. Fundamental rights. Fundamental rights include, but are not limited to, A. The rights of privacy, to be left alone. Privacy usually implies in one's home, as there is supposedly no reasonable expectation of privacy while in public. The right to be let alone is, among other things, the in-public analog of the right to privacy. This means that no state official has any place bothering you in the first place. If they make any contact with you at all, or bother you for even a moment, You can think of this as them having failed to fuck the fuck off in the first place. In parentheses, and as men understand, this is clearly a grievous offense. Every natural person has the right to be let alone and free from governmental intrusion into person's private life except as otherwise provided herein. This section shall not be construed to limit the public's right of access to public records and meetings as provided by law. Florida Constitution, Article 1, Section 23. B. Due process. Constitutional law guarantees a person due process. State employees rarely honor this. Due process falls in two categories. A. Procedural due process, notice, opportunity to defend. B. Substantive due process. Laws must be of such substance as they can reasonably be expected to be obeyed. C. The right to freedom from harassment. All persons have a right to be free from harassment by their government, in parentheses, much less by anybody else. However, much of the conduct engaged in by police officers and other government operators on a daily basis falls under the legal definition of harassment, but for whatever twisted reasons, the court has decided that the state may harass you as such. It's not that they have decided that the conduct is not harassment when engaged in by police or the state, but that the state supposedly has the right to do so. Well, you decide this. D. Freedom of speech. Loss of First Amendment freedoms for even minimum periods of time is irreparable injury. Supporting preliminary injunction. Springfield v. San Diego, Unified Port District, SD Cal 1996 950 F SUPP 1482. Constitutional rights to assemble peaceably and to petition for redress of grievances are intimately connected both in origin and in purpose with other rights of free speech and free press under this amendment, and all these rights, though not identical, are inseparable. United Mine Workers of America, District 12, verse Illinois State Bar Association, U.S., Illinois, 1967, 88, S, CT 353. A broadly defined freedom of the press assures maintenance of American political system and an open society. Time Incorporated v. Hill, U.S. NY 1967, 87, S, CT 534. The purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of the political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. West Virginia State Board of Education v. Barnett, USW, VA 1943, 63 S.CT.1178. The constitutional protections for speech and press were fashioned to assure unfettered interchange of ideas for bringing about political and social changes desired by the people. New York Times Company v. Sullivan, U.S., ALA, 1964, 84 S.CT 710. It is purpose of this amendment to preserve uninhibited market place of ideas in which truth will ultimately prevail, rather than to countenance monopolization of market, whether it be by government itself or private licensee. Red Lion Broadcasting Company v. FCC, U.S. District, COL, 1969, 89, S.CT.1794. Principal function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Texas v. Johnson, U.S. Tex, 1989, 109, S.CT.2533. Constitutional right of free expression is intended to remove governmental restraints from arena of public discussion, putting decision as to what views shall be voiced largely into hands of each of us in belief that no other approach would comport with premise of individual dignity and choice upon which our political system rests. Simon and Schuster, Incorporated, versus Members of New York State Crime Victims, BD, USNY 1991. At the heart of this amendment is the ineluctable relationship between free flow of information and self-governing people embodied in our democracy's firm conviction that wisdom and justice are most likely to prevail in public making decisions. Of all ideas, discoveries, and points of view are before citizenry for its consideration, and accordingly, courts must remain profoundly skeptical of government claims that state action affecting expression can survive constitutional objections. Thomas v. Board of ED, Granville Central School District, CA 2 NY 1979. E. Right to keep and bear arms. There have been recent U.S. Supreme Court decisions regarding the Second Amendment of the U.S. Constitution, and it is of the utmost importance that every citizen understand this law and where it is going. Guns and other arms are necessary to protect public safety. For example, police officers commit acts of violence against the public all the time. That is a danger to public safety. In parentheses, it may not get shown on television, but the stacks at the law library are filled with such cases. It is likewise important to understand that most, if not all, states have provisions in their state constitutions that are similar to the Second Amendment of the U.S. Constitution. This adds a second layer of protection to your right to keep and bear arms. This is important because if the U.S. Supreme Court chooses to interpret the Second Amendment in such a way as to limit or restrict that right, such law can be used to strengthen it. F. Personal space. Police officers have an annoying habit of coming up to you and getting in your face, and typically yelling and screaming like punks. It happens all the time. If a police officer enters your personal space, you must file a complaint against them on the website. We will assist you in obtaining a restraining order. You are not required to warn a person in advance not to approach you, much less enter your personal space and annoy, alarm, harass, or threaten you. G. Free expression. Free expression is protected by the First Amendment. It does not cover acts of violence against another regardless of how much you would like to express yourself by beating someone's ass. Likewise, art installations on public property seem not to be covered either. So, a picture of your local sheriff wearing a dress may be free expression, but apparently the state can prevent you from hanging it in the courthouse lobby. Things like music, television, and other media that may not be of the press, per se, are covered under this provision. H. Criticism of government. Criticism of government is likewise protected by the First Amendment, and is perhaps one of our strongest protections. If you have been threatened or harassed, in parentheses or worse, by any police officer or government agent for criticizing government, you must file a complaint on the website. There is a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that, in parentheses, such debate may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. New York Times v. Sullivan, 84 S, citation at 721. Criticism of government is at the very center of the constitutionally protected area of free discussion. Criticism of those responsible for government operations must be free, lest criticism of government itself be penalized. Rosenblatt v. Baer, U.S. S.C.T. 1966. First Amendment protects even profanity-laden speech directed at police officers. Payne v. Pauley, C.A. 7, in parentheses 3, 2003, 337, F3D, 767. I. Protection for your personal property. If you have had your car impounded and held for the payment of a fee, in parentheses typically an ever-increasing fee, then you have a claim. Simple as that. There are a series of forms on the website to help you deal with this. Likewise, if you have had other property seized. Otherwise nominally private activity of defendant in depriving plaintiff of his motor vehicle under impoundment procedures authorized by municipal ordinances and FRS Statute 85.031, subsection 3, becomes state action as a result of defendant's relationship with and participation in conduct of sheriff and deputy in respect to impoundment. Hahn v. Carson, M.D. Florida, 1978, 462, F. SUPP. 854. Ordinance allowing towing or impounding for violation of any traffic law was overboard, since there is a strong private interest in use of a vehicle, since the risk of an erroneous deprivation of said interest through the procedures used was substantial, and since there would be no great fiscal or administrative burden in making the ordinance more specific with respect to exactly which ordinances present prosecutions whose violation will subject a car to the risk of towing. Furthermore, the ordinances was unconstitutional in practice, since notice is not sent promptly and storage fees are assessed prior to sending notice. Gillum v. Landrieu, Landrieu, E.D. L.A. 1978, 455, F.SUPP. 1030. Procedure wherein prisoner was given notice of pending disposition of his impounded automobile by way of certified mail, return receipt requested to prisoner at his home address, when state knew that prisoner was in jail, denied prisoner due process. Seals v. Nicole, that's Nicholl, N.D.I.L.L. 1973, 378, F.SUPP. 172. Impoundment statute, which authorized impoundment of vessel, was constitutionally defective, and that there was no provision for meaningful hearing even after seizure. Nolt v. Isidore, D.C., Alaska, 1984, 590, F.SUPP. 518. Impoundment and warrantless inventory search of defendant's automobile were unreasonable where defendant was not advised that impoundment need not occur if reasonable alternative was provided, and where defendant's suggested alternatives to impoundment were not even considered. Judge v. State, APP 2 DIST 419 SO 2D 1171 1982. Where police officers, although informing arrestee that his truck was going to be impounded, did not inform arrestee that impoundment would not occur if arrestee could provide reasonable alternative to impoundment, contents seized during inventory search would be suppressed. State v. Miller, APP.2 DIST.404 SO.2D 159 1981. Even if defendant were lawfully in officer's custody when they learned where his car was parked, they had no legal basis to search his car without a warrant or his consent. Cuva v. State, APP.5 DIST.687 SO.2D 274 1997. Police officer illegally seized items in plain view inside passenger compartment of vehicle when, after encountering motorist parked on right-of-way and ordering motorist to exit vehicle and walk to the police car. Officer then approached motorist's now vacant vehicle and looked inside, assuming arguendo that officer, for his own safety, could order motorist who had not committed any violation of the law to exit vehicle in order to check on motorist's well-being. Officer then had no jurisdiction or justification for then inspecting motorist's vacant vehicle, and officer had no probable cause to make any arrest until items were observed inside vehicle. Jenkins v. State, APP.5, DIST.567, SO.2D 528, 1990. Patrolman's failure to tell defendant that his car was going to be towed away and failure to give defendant reasonable opportunity to provide alternative to impoundment rendered inventory search of defendant's car illegal and evidence gathered therefrom inadmissible. Moore v. State. APP 5 DIST 417 SO.2D 1131 1982. Detaining a driver and his vehicle for an inordinate amount of time is unreasonable seizure. Gluesenkamp v. State. That's GLUESENKAMP v. State. 391 SO.2D 192 1980. Removal of vehicle identification number in parentheses VIN sticker from defendant's car by private citizen who has acting solely at discretion of police officer was an illegal seizure in violation of defendant's Fourth Amendment rights. Glasser v. State. APP.4DIST 737 SO.2D 597 1999. There was no basis for impounding vehicle which defendant was driving, even though he could not produce vehicle registration or proof of ownership, where he did give the officers the name of the owner. Montalvo v. State, APP.2DIST 520 SO.2D 292 1987. J. Freedom of thought. We reach a different plane of social and moral values when we pass to the privileges and immunities that have been taken over from the earlier articles of the Federal Bill of Rights and brought within the 14th Amendment by a process of absorption. These, in their origin, were effective against the federal government alone. If the 14th Amendment has absorbed them, the process of absorption has had its source in the belief that neither liberty nor justice would exist if they were sacrificed. Twining v. New Jersey 211 U.S. 99. This is true for illustration of freedom of thought and speech. Of that freedom, one may say that it is the matrix, the indispensable condition of nearly every other form of freedom, with rare aberrations. A pervasive recognition of that truth can be traced in our history, political and legal. So it has come about that the domain of liberty, withdrawn by the 14th Amendment from encroachment by the states, has been enlarged by latter-day judgments to include liberty of the mind as well as liberty in action. Palco v. Connecticut, 302 U.S. 319, 1937. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance. UN Universal Declaration on Human Rights, Article 18. This is where the psychology mentality is so nauseating. Those type claim that people have disorders based on the content of their thought or the nature of their personality. When listening to these people, instead of being sucked in by their manipulative conduct, in parentheses, note that they practice their behaviors constantly in order to appear as acting natural, take a step back consciously and analyze what they say in terms of constitutional law. Hopefully, then you will see the sickness at hand. Remember that these people make a practice and profession of, in parentheses, not to mention a preoccupation with, engaging conduct that is against both universally recognized principles and the law of this land. While studying human thought and behavior are certainly constitutionally protected, as well as opinions about such things, when state action is taken on grounds of a person's supposed thought content or personality disorder, then that action becomes immediately questionable under constitutional law, if not prohibited. This is directed particularly to anyone who has had to seek court-ordered counseling, therapy, treatment, or who has had to deal with a psychologist, psychiatrist, social worker, caseworker, or otherwise from the state. If this has happened to you, there is a form on the website that you can fill out to solve the problem. Likewise, if you have been ordered to deal with such persons, understand in advance that these people will act perfectly friendly, polite, and amicable to your face. Then write a report about how you have all manner of things wrong with you, in parentheses, because you're you, presumably, and of course, why you need to take part in some state mandate, treatment, program, or another that ultimately subsidizes them. It is a good idea to simply not talk to these people at all, or at minimum record the sessions, or have a witness during any state-ordered treatment. H. And more. The Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Just 'cause it ain't there doesn't mean you don't got it. In other words, the Ninth Amendment leaves room for constructing, in parentheses, interpreting laws, but whether or not the courts will interpret it as an extension clause is questionable. However, it is important to never believe any government official who tries to con you into believing the government creates or grants rights. Rights exist regardless of anything else. What governments are to do is restrict or protect them, and all too often usually violate them. 6. Police authority. No police officer has any authority that you did not give them, in parentheses CFRS 447.209, to use Boca Raton as an example, in parentheses your municipality may vary. The Sororital Order of Police, Lodge 35, is a private organization, in parentheses a labor bargaining unit, which has a contract with the Municipal Corporation of Boca Raton to provide services as a police department. The contract has several fatal flaws, and such needs to be rewritten at least, if not rescinded. Whether the police have any authority at all while operating under an unconstitutional contract may be in question. The current contract, which expires 30th September 2013, has, for example, the following provisions. 1. No tobacco policy. Drug use will get you counseling and treatment, but tobacco use gets you fired, or just not hired in the first place. It's a legal product, in parentheses, whatever good, bad, or otherwise it may do, and there must be at least some tobacco users who wish to get that job, in parentheses, not to stick up for wannabe cops, of course, but invidious discrimination is about the worst kind. 2. This unit gets liability protection, but if your company cleans the toilet at City Hall, you have to provide your own slip and fall insurance. Same with any service contractor. Unequal protection of law here. Ouch. Either everyone gets the same deal or no one gets it. No exclusive franchises. 3. Per Florida Statutes, Chapter 447, the public employer unilaterally decides the purposes of its departments. You are the public employer. Do not ever tolerate a police officer attempting to suggest they have the authority to act as they wish. They are your subordinates and must be conformed by you to act as such. Action item. The Boca Raton police contract is up for renewal soon. Now is an opportunity to get involved. We have a form on the website for that. By simply filling out a form, you can see to it that their new contract will contain appropriate compliance provisions that you set. Even if you do not live in Boca Raton, please get involved. After all, you may find yourself in Boca Raton one day. Then what? If a cop tries to tell you that they do what they want, or cop that attitude with you, you must report them. The website has a form that, remember when dealing with a police officer, always make note of their name at least and their badge number before answering any questions or listening to anything they say. Be sure to commit it to memory. Repeat it to yourself at least 3 times. You will need this information when filing a complaint. An officer's identity can be obtained from various public records, but this slows the processes down considerably. Sometimes it can take days, others it can take weeks. But if an officer's identity is known, a complaint can be filed with the department. Before the officer finishes harassing you, if you are being harassed by a police officer, call 911 and claim that the officer is harassing you and / or threatening you, or if nothing else, is just acting like a dick and needs to be fired. And be sure to give the officer's name and badge number to the dispatcher. In parentheses, you can use that language if you want, and if the 911 dispatcher harasses you for using it, file a complaint on fireacop.com, along with the complaint against the officer harassing you. 7. What kind of assistance is available? There are several different services on the website available to help. Free complaints, fill out a form, provide the facts, persons involved, and problem caused, and what sort of corrective action is needed. A printed copy of the complaint will be generated. You can download it, sign it, send it, or lodge it in our database for future information. Paid services. If you believe a complaint is such that it needs to be followed through upon, then assistance with paperwork and follow-up is available. Prices start as little as $10. This is for processes not involving lawsuits. In parentheses, for as little as $10, an administrative complaint can be lodged with whatever department and seen to it that it is placed in the officer's department file. Pro se legal assistance. If you want to pursue declaratory judgment actions, injunctions, writs, or other such claims, assistance is available for those representing themselves. Free forms to start the process are on the website. Note, if you are seeking monetary damages, contact a civil rights lawyer or learn to do it on your own. The process is sufficiently complex that it should be undertaken by a competent lawyer or a sufficiently motivated individual. However, if you are seeking injunctions, writs, declaratory judgments, and non-monetary punitive damages, in parentheses, i.e., equitable relief, then the website has resources to help. 8. How you can participate. 1. Provide us with a commercial email account, in parentheses, Yahoo, Gmail, Hotmail, AOL, etc. We sell those addresses to marketing companies as highly qualified marketing leads. In parentheses, this costs nothing to you, except a little time, but that information can be sold to marketers to help raise funds. You will also receive newsletters, updates, and information regarding your case at this address. This is for people who wish to receive advertising. In other words, you agree to receive spam, in parentheses, advertising email. but set up as a separate account to do it. In parentheses, it is usually best to do this through a free system like Yahoo or Gmail. The website has a sign-up page with a selection form that allows you to decide what types of local and national products that you would like to know about. You can receive specials from national and local companies selling food, clothing, automobiles, and other consumer products. For example, you can receive emails with coupons for local eateries. This helps support local merchants in your area and pay for this publication. The system is geared toward local and national consumer products. In parentheses, not medications, personal aids, or investment scams. These are prohibited from our advertising system. 2. Pay $10. This document costs about $1 to $2 in printing costs, and we print thousands. You can help by paying $10 for this document on our website. A PayPal button is available where you can pay by debit card or online account if you have one. 3. Use our services. Simply use one or more of our inexpensive paid services to lodge a complaint and follow up. For less than $100, you can lodge a complaint, and a person will follow up with the officer and the department. If you simply wish to complain but take no action, that is free. In parentheses, we encourage you to complain for any reason you feel just. We keep records of all complaints and follow up regularly. The complaints that are lodged are printed and mailed to the department. This is why it is so important to record all acts of abuse by government. Until some kind of record is made of the wrong, it is difficult to actually do anything specific about it. Once a record is made, however, claims can be pursued. 9. Reasons to file a complaint. Mandatory complaints. If any of the following have happened to you, you must file a complaint against the officer. 1. Was your license suspended for any reason not related to highway safety, in parentheses, not paying a ticket, failure to appear, child support, or other issues? 2. Did any police officer harass, annoy, or threaten you in any way? 3. Did they search or impound your vehicle? 4. Were you sprayed with chemicals or electrocuted with a taser or threatened of such? 5. Have you witnessed any police officers appearing on public or private property wearing masks over their faces? If you have witnessed or been subject to any of these occurrences, you must contact us via the website. These are all violations of the law. If you are male and your license has been suspended for family issues, or you have any state child protective services interfering with your relationship with your children, you must lodge a complaint on the website. There are a number of problems with this situation that need to be taken care of like men. 10. Case law. Case law, as it is sometimes referred, means typically decisions by or opinions of courts of record regarding matters of law. Doing legal research can mean reading lots of case law. However, much of the information is available on computers. Lots of case law is now available on the internet as well, and there is even more available via paid search services. Likewise, printed volumes of case law can be found in state and county law libraries, in parentheses, in Delray and WPB courthouses, for example, and university law libraries. There are two main companies that provide electronic case law searching, LexisNexis and Westlaw. These companies also keep a wealth of personal information on you as well. Stuff you thought nobody else knew. Yes, they know it. In parentheses, when employers do background checks, for instance, they may obtain information from these companies. Using case law is how arguments are made in court, and generally speaking, the more you have at hand, the better off you are. Starting around the 1970s, electronic case law database, in parentheses like those from Lexis and Westlaw, started to emerge, and until recently, that information was only available on an expensive subscription basis. Combined with word processing programs, a lawyer could pull case law out of a computer and paste it into his pleadings in a much more comprehensive and efficient fashion than, say, a pro se litigant who had to use the law library and a typewriter or pen. This was an enormous time/cost advantage that led to both the state and lawyers ultimately being able to produce more lawsuits at a lower cost than previously available. That has not changed. But now, most of the same tools and information are available to the public at large, and every state officer, and likewise, reproduce the burden that those individuals place upon private sector individuals and the invasion of people's existence that they engage in. The statements in the preceding pages that cite a court case as plaintiff versus defendant, etc., are an example of case law. The following citation, or cite, of a famous U.S. case, for example, Marbury v. Madison, 1 Cranch, 137, 1803, corresponds to parties, in parentheses, record, page, in parentheses, year. A legal cite will usually indicate the parties in the case, the court that decided the matter, which record is being quoted, the page number, and the year. Each state has at least one official record. There are also several records of the federal system. Private publishing companies also publish records of official proceedings that can be cited. To cite a case, a relevant statement from the full opinion is quoted, and the names of the parties in the case, and the court that issued the opinion is used. Using a precedent to make your claim is the general idea. For example, you may want to try to convince a jury in a federal court that your local traffic court and police department should stop robbing you because the U.S. Supreme Court has said over and over that they should. 11. Doing legal research. To use Lexis or Westlaw on computer, try the computers at a library under the Florida State University system. Your county/municipal library may have it as well. Almost any decent library will have printed copies of Lexis and Westlaw products. Courthouses typically have a law library for legal research. It is a good idea to browse the stacks of a law library in addition to doing research on the computer. As an exercise, try going to the law library in the courthouse when you're waiting for your case or finished, and look up and read the following case: Bradwell v. Illinois, 83 U.S. 130, 1873, U.S. Supreme Court. Here are some recommended legal research volumes. 1. Black's Law Dictionary, a very simple and straightforward way to learn the law. Simply flip the pages and you can learn a wealth of legal concepts in one setting. A great way to get started. 2. Words and Phrases, 1658 to date. This is an encyclopedia set with thousands of pages of court opinions explaining just about every legal word and phrase imaginable, and, as the name suggests, the opinions date back to the year 1658. 12. Internet legal resources. State law, Florida Revised Statutes, in parentheses FRS, can be viewed online at http://www.leg.state.fl.us/statutes. Florida State Legislator website. Federal law, United States Code, in parentheses USC, can be viewed online at http://thomas.loc.gov. Library of Congress. Federal Court Rules, United States Code, http://www.law.cornell.edu/. Cornell University. In parentheses, they do a good job. Please donate. Florida Court Rules, http://www.floridabar.org/. See Professional Practice. Rules of Procedure. Practicing good citizenship every day. http://fireacop.com.